And we're live. Ready to go. Yep.
All right, welcome to Senate Judiciary. We are continuing Senate File 117. Here, will you please call the roll?
Senator Crago,
Here.
Senator Crum,
Excused.
Senator Hicks,
Excused.
Senator Kolb,
Present.
Chairman Olson.
Here.
You have a quorum.
All right, and yes, Senator Pearson, we just finished up with you. Nope, you can hang out. You're good. We finished up with your testimony and we will move to our state agencies. Welcome. Who wants to go first? Ms. Butler?
Mr. Chairman, members of the committee, my name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. We do not have a position on this bill, but there are a couple of things that we wanted to point out just in terms of impacts to the court and navigating the bill that is currently in front of you. So one thing that I think, hearing from our judges that they anticipate if this bill moves forward is they actually anticipate that this will create more contention between the parties. We anticipate there will be more appeals coming out of these kinds of cases just based on the fact that there would be now a presumption of shared custody. And then the other thing that just logistically in terms of the bill itself, there are a few things that I think the judges may have a difficult time navigating in the way that the bill reads today and how the
Can you help me
statute
with the first
would read in the
statement?
future.
More appeals?
More appeals with the presumption of shared custody. And so what would happen in those circumstances is you have the presumption of shared custody that is ordered. And often, I don't want to say often, but yeah, oftentimes when people are in the court system and they're asking the court to determine custody, the reason for that is because they cannot agree, right? And generally, what you see is with the presumption of shared custody, you will likely have one parent who is not happy with that agreement. So you'll see more appeals coming out of those cases, we anticipate.
Gotcha.
There is nothing scientific behind it. It's just something that we anticipate in the future. So, Mr. Chairman, looking at the bill itself, you have 22201A, which provides what we would say now is the general analysis of where judges start when they have a custody determination to make, and that is to look at the best interests of the child and consider the 10 statutory factors that are laid out in subsection A. If you move down to subsection D, the way the bill reads now is with the presumption of shared custody, the question would become, how do the judges navigate between subsections A and D? And so if we start with the presumption of shared custody, do we do away with the idea that we're looking at the best interests of the child? What takes primacy in those analyses and what should that look like for the judges? So I think what this bill leaves us with is a little bit of uncertainty in terms of how the judges should analyze these kinds of cases. And I think the other thing that you all have addressed or were addressed potentially through some of the amendments that were suggested yesterday were a couple of things that the judges had indicated could be problematic, and that is the first one was the clear and convincing evidence standard within subsection D, Romanet 5. I think that potentially is cleared up with the amendment. But the other piece here that is really concerning, I think, for the judges is in Romanet 4 of subsection D. And that would be the language that says the parties no longer reside within 300 miles. I don't know that that's cleared up by just removing that section, because essentially what it does is it broadens It broadens it. So it basically says shared parenting is the presumption all of the time, regardless of where the parents live. And I know that there's the catch-all in Romanet 5, where you could say if the parents live 2,000 miles away from each other, that is something that the judges could use. But it does create a presumption that regardless of where the parents reside, shared custody will be ordered. And so I think there's just a lot of confusion in the bill, or will be a lot of confusion with the bill in terms of how the judges are going to analyze these kinds of cases. And one of the biggest ones is, where does the best interests analysis lie now, if this bill passes? How does that play into those analyses that the judges are required to look at when they're determining these custody cases? And Mr. Chairman, just a couple of things that I wanted to make sure to address, because I think there are, I don't know if they're misconceptions, but things that I think you and maybe other members of the body should understand, and some of you probably do. But the statute actually requires that when parties come into court to request a custody determination, they are on equal footing. The statute actually requires it. That language is in the statute today. So there is an equal playing field. When parties agree on custody arrangements, generally those custody agreements are going to be agreed to by the court. They will sign off on those. There are some, I would say, rare circumstances, I don't know how rare, but there are some circumstances where the judge will say, no, that's not in the best interests of the child. But oftentimes, if the parties are in agreement on how custody should go, the judges are going to, the parties would offer that as a stipulation, and the judges will agree unless there's some good reason not to. And so generally, the only time you're going to get into those analyses of best interests of the child and the presumption of shared custody is when the parents are asking the court to make a decision. So they can't agree between themselves, and they need somebody else to help them make that determination. So Mr. Chairman, those are the points that I wanted to bring to your attention today. I'd be happy to answer any questions that you all may have.
Committee, any questions for the courts? All right, thank you, Ms. Butler. Pierre, have you let Mr. Williams in? Okay. All right, looks like you're all by yourself.
Thank you, Mr. Chairman. Hopefully he can hear my testimony and understand that he needs to accept the invitation. Thank you, Mr. Chairman. My name is Corin Schmidt. I'm the Director of the Wyoming Department of Family Services. As the judicial branch stated, we don't have an opinion necessarily on this legislation. This is a private custody matter. It is not one that involves the Department of Family Services when we talk about state custody. This is a matter between parents that are conducted in private situations. However, there is a potential, because some of the changes to this bill, that it may start to incorporate some of the child support program. And so because of that, we wanted to bring it to your attention just so that we can make sure that if that was not the intention, that maybe there's a potential conflict with paternity, how we establish paternity compared to what's listed in the bill. And I'm seriously hoping Mr. Williams can join. Okay. So, Mr. Chairman, a little bit about the DFS arrangement. We have brought this to your attention at the request of the child support attorneys throughout the state. Mr. Williams, if he joins, is an attorney with the Child Support Authority up in Johnson County and in Sheridan County. And essentially, we provide administrative support to the program, but the actual attorney work, the actual judicial work happens locally through contracts.
I think I'm here now. Can you hear me?
You made it. We can hear you.
Okay, perfect. I'm not sure what happened. Sorry about that. All right, so if I may, my name is Mike Williams. I am the attorney and director for the Child Support Office in Sheridan and Johnson County. The area that I was asked to testify today with regards to this bill is a concern that the child support attorneys throughout the state have. And it's with regards to lines 2 and 3 in subsection A, which talks about paternity actions being added to the mandatory custody. What we're concerned about is that when the majority of paternity actions are brought by the child support agency. And so when we are determining fatherhood, who the father is in the paternity action, we don't get into the custody and visitation portions of the process. So pursuant to Wyoming Statute 20-2-201H, it basically says that a court finding of a physical placement of a child in a child support order shall not be considered disposition of custody. So the concern that we have is that by including paternity actions, all of them, we would then become involved in the custody and visitation orders, which isn't what we're allowed to do under the child support regulations that govern the program. What we would, I guess, request is just in line 3 of subsection A, where the sentence says pursuant to Wyoming statute 14-2-401 through 14-2907, if we could add a provision after that that says, except in actions brought by the Child Support Enforcement Agency, that would be enough to resolve the concerns that the Child Support Agency has. Because that would exempt us from doing that, from being involved in that aspect. And with that, I would be happy to stand for any questions.
Any questions for Mr. Williams? So on line 2, after the comma, insert except in actions brought by a child support agency.
Correct. I think the actual language that we got was except in actions brought by the Child Support Enforcement Agency, which is a term used in statutes in other places.
Child Support Enforcement Agency. And is it the Child Support Enforcement Agency or a Child Support Agency?
The language that we'd come up with was the, but I'm wondering if we wouldn't be better just to put brought by the Wyoming Child Support Enforcement Agency.
Okay, good thing they give us pencils here. Got it? Any questions for Mr. Williams? All right, thank you, Mr. Williams.
Thank you.
And that's all you have? All right. Thanks, Ms. Director Schmidt. Any other agencies wishing to testify on this bill? If not, I will open it to general public comment. We do have quite a few people signed up online. Just so you're aware, in the online world, I'm going to take testimony from the room first, and then we'll go to those who are online. So if you're online, just be ready and we'll let you know when it's time to come in. Testimony in the room. Yeah, please come forward. You can fill up the chairs if you want.
Mr. Chairman, members of the committee, my name is Lynn Story-Heiler, and I'm the Director of Safe Harbor at Children's Justice Center. We're located here in Cheyenne, Wyoming, and we are a supervised visitation and safe exchange facility. We're a nonprofit organization, so I'm very familiar with families who are going through difficulties with custody and entanglements like we're talking about here. I'm going to change my remarks just a little bit because when you got into paternity, I'm going to highlight a story about how we actually got started. So when we got started as a facility, we had a really awful case because judges didn't have tools that they could use. There's a little boy named Robbie Nemeth Bates. And Robbie was living life and had a really good time with his mom. His mom had had a one-night stand with an individual, and she made a baby. Robbie's dad had never been in his life, but mom needed to establish some assistance with the state. So they made her go through paternity. Well, when they made her go through paternity, Robbie's dad was identified. And at that point in time, the courts, all they had to do was order standard visitation. So Robbie's dad was ordered standard visitation. And within 3 months, Robbie was dead because the courts didn't have a way to assess how people maybe were going to be in that child's life. So I bring that to you because when it popped up about paternity, I think that these cases are very complicated. Child custody and divorce are very, very complicated cases. There's not one standard for all cases. On paper, this bill theoretically looks fantastic. You're right. It can do some stability for children's relationships with their parents. I don't think it reduces any conflict. It can be flexible. It can promote co-parenting. But in reality, if you only go to this as the first level, you're actually making it more difficult on kids. And we have to look at the kids. We have to look at the best interest. Kids will live in 2 separate houses. And that could be 1 week on, 1 week off. That could be 1 month on, 1 month off. It can look really, really different. But kids have to have 2 different houses, 2 different bedrooms, 2 different stuff where they place their stuff, 2 sets of friend groups. And I just don't know that that's in the best interest or maybe creates more trauma for kids. In my experience, when people get divorced, there's a reason they get divorced. They don't like each other anymore for whatever reason. So in theory, when you say that it's all going to be rosy and everybody's going to get along, that's not our experience at Safe Harbor. Most of the time we deal with people who are angry and frustrated and resentful and have hatreds towards each other. Most of our families that we work with don't even like to communicate together. They do it through texting or the parenting app. There's a talking parenting app. Can you imagine having these meaningful conversations about shared custody through those ways? I did put in there child support. That's a whole nother thing in terms of, you might have a dad that has a really good career and they get divorced and mom maybe works at a convenience store or something like that. If you share custody, dad's house will be Disneyland. The kids will get all kinds of things and it'll be a wonderful place to live. And then at mom's house, she might struggle. That creates conflict between them and the kids know that, they see that. Just in my 25 years of experience, I think judges are doing a good job right now of what they're doing. I don't think we need to legislate starting at 50-50. If we've got some judges that aren't doing a good job of that, then it's our job to educate those judges. But I just see too many problems with this bill, and I would ask you to vote it down.
Any questions for Ms. Story-Heiler? All right, thank you. You're up.
Chairman Olson, Senator Crago, Senator Kolb. My name is Abigail Fournier. I am an attorney in Cheyenne native, although I live in Laramie. For the last 12 years since graduating from the University of Wyoming College of Law, I've practiced exclusively family law. I am a huge proponent of shared custody when it works. I represent an equal number of fathers, mothers, and I also represent the best interests of the children regularly as a guardian ad litem. My firm has cases in all 23 counties in Wyoming, and I think what we're seeing increasingly, given some recent case law, is already moving towards shared custody, especially where it's feasible, where it's appropriate, where it's in the best interests of the kids. In my opinion, this bill seeks to fix a problem that doesn't exist. We have great judges who are able to craft really unique, excellent parenting plans and custodial arrangements for individual families, given the consideration of 10 statutory factors, as well as decades long of
of case law. And I think when it was indicated yesterday by Senator Pearson that this bill intends to ensure that parents come to the courtroom on equal footing, we already see that. The statute as written, and not in its proposed edits, but as written, specifically states that a parent shall not be given preference on the basis of gender. Our case law states shared and primary custody shall be equally considered, that neither receives preference over the other. I think Senator Olson, Chairman Olson, excuse me, made excellent points yesterday about any number of issues that you might have in an individual case, and that it's very difficult to narrow that down to just one or two exceptions where a solution may fit. There was also testimony yesterday, and Ms. Butler spoke on it earlier, about the judiciary enforcing stipulated agreements. And I'll say I can't think of a single case I've had where the parents have agreed and the court has said, we're not going to order that. And 9 times out of 10, if you have parents who can agree, we don't see those cases in the courts. They're able to put their divorce decree in a drawer and never look at it, and they never appear in front of the court. To imply that shared custody can work when parties are in the courtroom disagreeing over the most important thing in their lives, their children, I just think that's unrealistic. Another concern I had is that the definition of joint legal custody in this bill is not exhaustive or feasible. The bill strikes important language that would allow both parents equal access to educational documents, medical records. We see a lot of custody cases where that legal language may not be identified in a decree, but it's in the statute, and it allows a party to make sure that they have access to those items. I agree with Ms. Butler that if this legislation were passed, we'd actually see an increase in litigation. And I don't think it would be about custody issues in terms of who should receive primary, who should receive shared, what the visitation arrangement should look like as we do now. I think we'd see a lot of really small emergent issues on legal custody items, such as, should my kid take ADHD medications? Should my kid be vaccinated? Are we going to go to this school or this school? And I think it'd be a huge strain on our judicial system to have parents needing to identify and resolve these immediate concerns for their children when you don't have a tiebreaker. So if you have one parent who has primary legal custody or physical custody, you have a tiebreaker. And when you take that out, I think we're going to end up with a lot more litigation. The bill mentions that shared custody would not be preferred in situations where there's a conviction of domestic violence or child abuse and neglect. We see so many cases where domestic violence, child abuse, and neglect are occurring and there's no conviction, or maybe there's a conviction that comes out a year or two after the custody disposition has already been entered. A proposed amendment yesterday said that there would be, a parent would be disfavored if they made a false claim of domestic abuse or neglect. And I really think that the existing statute already allows for the court to consider that if someone makes false claims for the purposes of having a leg up in a custody disposition. I think it's a testament to this bill that it's working. Senator Hicks talked yesterday about how long it took to get through all of these individual statutory factors. And I really do think that they allow our courts to craft really great arrangements that aren't cut and dry for our Wyoming families. I also believe that this case would override a lot of important precedent, a lot of ability for the court to consider best interest factors that are outlined in our case law. And I think actually what we'd see, not only in terms of increased appeals when parents are upset about the outcome of their case, but I think we'd also see a lot of parents arguing that whatever burden you impose, preponderance of evidence, clear and convincing, that that's not met. So I think we'd see a lot more appeals on those issues. overall, I really believe that our judges in Wyoming, in my experience, are thoughtful, they're comprehensive. They really take time to make sure that individual custody dispositions meet the needs of families, and they don't always get it right. I think anyone who's practiced family law has had cases where they're upset at the outcome. Parents certainly are never happy when they lose time with their kids, but there are remedies that you can modify, you can appeal. And I think if this bill is passed, we're gonna get it wrong a lot more. Thank you.
The way this bill is crafted, it has this list of exceptions to shared custody. But to me, Romanet 5 really is a catch-all. And my question for you is, if this legislation were to move forward, do you feel like Romanet 5 provides enough flexibility for judges to be able to find where the exceptions exist, to find their way out of a shared custody arrangement? Because, I mean, it's a low, particularly if it were amended to a preponderance of evidence. It's a pretty low standard. They just do a best interest analysis, which they have to do anyway. And they can find their way out of a shared custody arrangement. Is that, am I reading that right? Do you think that's enough?
Thank you, Mr. Chairman. I think that my concern with that is, as the statute reads now, you start with the best interest analysis, and you have 10 factors, and then a lot of case law that comes in under the last factor that allows you to really work through that best interest analysis. And the way I see the way that this bill is written, you don't get to the best interest until the very end. And I think that that's a mistake. I think that the statute as it is now prioritizes the best interests of kids. I think this overlooks the best interests of kids in the light of, in favor of parents who maybe couldn't get along and have decided to separate or divorce. And as it's been stated before, if they could get along, they wouldn't be in the courtroom.
Any other questions, committee? Senator Kolb?
Yeah, thank you, Chairman. Counselor, just in your experience, this bill's trying to get at the, making a situation of joint shared custody first, right? And how do you see it? If their experience, what happens? I mean, do the judges consider this first, or is this way down the old list of things they consider? Because I think from my point of view, it seems to be a valid point that it is the best interest of the child to have joint or shared custody, but obviously it doesn't always work out. But how do the judges look at it, in your opinion, from your experience, when it comes to that question? How do they prioritize the outcomes when it comes to a joint shared custody question? Thank you, Mr. Chairman.
Ms. Fournier?
Thank you, Senator. I would say that any parent, any lawyer who practices in family law would agree that the best case scenario for any kid is to have two parents who are actively involved in their kid's life, that want to spend an equal amount of time with their kids. What we see, unfortunately, however, and what I know judges see, is that divorce doesn't always bring out the best in people. There's a reason why marriages deteriorate. And unfortunately, what we see is that children are often used as a weapon in divorce. And that parents don't often seek shared custody because they think it's what's best for kids. And kids end up being weaponized. I think judges like to consider the statutory factors in deciding whether or not shared custody will be feasible. And there's a lot of reasons why it won't be feasible, and why I said I think we can anticipate a lot of smaller item, emergency temporary hearing item issues on legal custody if this bill is passed, because judges have to anticipate whether these parties can agree down the line. And a lot of the times they just can't. And that's unfortunate, but we see it day in and day out. And I think by assuming that parties can get there, I think it's a great ideal. I just don't think it's realistic.
Follow-up, Senator Kolb?
Yeah, thank you, Mr. Chairman. Well, let me rephrase, Counselor. In your opinion, do judges weight the joint shared custody question at a higher level than, say, some of the other choice? I mean, if we're getting close to something, obviously, if it's damaging the children either physically or mentally, obviously they're taking that into consideration. But let's just say we're not talking about that. Do they weight that higher than the other items, or is it down on the list with everything else? I mean, that's really was my question. I hope I tried to convey that. Thank you, Mr. Chairman.
Ms. Fournier?
Thank you, Senator, and I apologize if I didn't answer it. I think that courts have to consider those factors to figure out what the best custody disposition is. So I don't think that they look at each of them separately or down a line. I think if they can get to shared custody, if that's what's best for the kids based on examining all of the individual statutory factors in case law, then they get there. I don't think that they start off thinking we're going to get to shared or we're going to get to primary off the bat. I think that they have to hear the evidence, take in the information, and decide what's going to be best for this family upon receiving all of that. So it might be the last thing that they consider. I think it's probably the most important thing they consider.
If I were creating a presumption, what I wish this bill does, but it doesn't do, is during the pendency of a divorce or a custody action, if you were to start with a presumption of shared custody during the pendency, so if all cases had a temporary order of shared custody, it would give the judge a period of time and the parties a period of time to see if it even works. And the judge could come to a conclusion at the end of that action, just the same as they do now, but that's not what this bill does, but it would certainly be nice. I think everything that you've said, I agree with in terms of people are in divorce court, they don't agree, they don't get along. There's a part of me that has a hope that if they share custody, that they're forced to get along for the best interests of the child. You would think that parents would have their own child's best interests in their heart and they would get along because it's the right thing to do, but it's just not a reality, I don't think.
I agree with that, Chairman, and if I may, I'll just say that if you have a presumption of temporary 50-50 custody, I would say in a great number of cases, you would end up with a final order that would result in 50-50 custody because you've established a status quo by making that determination.
Possibly so.
Thank you.
All right, thank you. Ma'am, welcome.
Hello. Oh my goodness. I wish I had 30 minutes to go rewrite my speech. My name is Laura Pavey, and I'm testifying today in strong support of Senate File 117, the Shared Parenting Act. This legislation represents not just a change in our legal code, but a fundamental recognition of what decades of research and real-world experience have shown us. Children thrive when both parents play an active and meaningful role in their lives. Under our current system, too many children lose significant contact with one parent or other following a divorce or separation. This loss often occurs not just because either parent is unfit, but just simply because our legal framework hasn't kept pace with our modern understanding of child development and family dynamics. This bill creates a simple presumption that both parents who have jointly raised and loved their children during marriage should continue to do so after separation. It maintains equal decision-making rights in education, healthcare, and welfare, while ensuring children spend a substantial amount of time with both parents. This bill does not force shared custody in situations involving domestic violence, child abuse, and neglect. It doesn't impose it when parents live hundreds of miles apart. It doesn't override agreements that parents make voluntarily. What it does do is start from the premise that both parents are valuable, both parents are necessary, and both parents should remain actively involved in their children's lives. The research supporting shared parenting is overwhelming. Children in shared custody arrangements show better emotional health, stronger academic performance, and fewer behavioral problems. They maintain strong relationships with both parents and extended family. They feel more secure and supported and better equipped to handle challenges of the growing up in a divided household. Some may argue that the change could increase conflict between parents, but experience from other states shows the opposite. When shared parenting is the norm rather than the exception, it actually reduces litigation. Parents spend less time and money fighting over custody because They are starting at a point that is clear and fair. This bill also recognizes the realities of modern parenting. Gone are the days when one parent was a sole breadwinner and the other was a sole caregiver. Today's parents share responsibilities, and our custody laws should reflect that also. You're not just voting for this bill today, but you're voting for the future of Wyoming families. We're voting on whether or not to give our children the best possible foundation during their life's most challenging transitions. We're voting on whether to recognize that both mothers and fathers matter and they both have equal footing, that both parents have value, that children deserve love, guidance, and support whenever possible. So currently I babysit a little girl, and her parents are doing shared custody, and they might go through little tiffs. They did not like each other as being a couple, but they get along great co-parenting. I also have a lot of family members who have gone through divorce, but it was so nice to see that they shared everything. They shared birthdays, and it really helped the kids thrive. And though they had their tiffs as being married, those tiffs kind of went to the side and they were able to co-parent amazingly together. So I urge your consideration of this bill today, and thank you for allowing me to speak.
Senator Craigo.
Thank you, Mr. Chairman. Thank you for being here today and for your testimony. You opened your statement by saying too many parents are losing their rights to see their children. And I'm just curious, and this is a question for you and maybe some of the other folks that are going to be testifying online, is do we have any statistics that line up with that? You know, exactly how many are we talking about? What percentage? I mean, I do a handful of these kinds of cases a year, and that's, in my world, that's just not the experience. That in my world, both parents end up getting some form of custody. Now, it may not be 50-50 because one of them leaves town or moves far away where it's not feasible, right? And so I'm just curious what exactly the statistics are on that.
So I could go and look that up. I did not bring, I'm an amateur. I could look that up and send it to you guys. I do have children, and I do have the kids that do come to our house that have divorced parents. A lot of the boys or girls, you know, they have weekend parents that they see every other weekend, because sometimes those parents only get to see their kids twice a month on 2 weekends. The parents that I do have that my children interact with that do get to see their parents, both parents, and do a weekend on, week off at their homes, those children that come in and out of my homes, they have so much relationship with both parents. It's not just a weekend dad or a weekend mom. They're really getting to experience those parents full time in 2 different settings. And so from my experience as a parent raising kids who have friends that have divorced parents, not from a legal aspect, from a citizen aspect, I see those children so much healthier and well adjusted, and they don't pit parents against each other because the parents are sharing. Does that make sense? Does that answer your question?
If I may, I think, not to put words in your mouth, but I think what you're saying to Senator Craigo's question, I think what you're trying to say is not that one of the parents has zero contact whatsoever with their children, but that when a parent is reduced to 2 weekends a month, that's that you've lost your child.
Yes, you have.
I
Yes.
mean, that's what I think you're saying.
Yes. And you've just lost that connection. Those dinners, those sit down at the kitchen table and doing homework or telling your kid, because we all know that when your kids come home or when you call them up, it's what are you doing? Oh, nothing, you know? So it gives children that opportunity.
Senator Craigo?
So a couple follow-up questions.
Please.
Thank you for that, Mr. Chairman. So in those circumstances, do we know if both parents live in the same town? That's part A of the question. And then part B of the question, do we know if, and a lot of times it's going to be the father, that the father decided he only wanted 2 weekends? I mean, do we know? Because that does happen. I mean, there are some times when the father says, look, I can't get the kid to school every single day. I leave at 6 a.m. to go to the mine.
Right,
That's just a
right.
good example. That's one I've run into in my world is the dad says, hey, I can't do during the week. That doesn't work for me. And oftentimes we'll do every weekend, not every
Right.
other weekend or something along those lines. Just following up on that because those anecdotes matter when we're trying to figure out the answer.
Chairman Olson, thank you, Senator Crago, for, I'm trying to learn lingo. Thank you for the question. I know of a child whose parents live in two separate towns. They make arrangements with other people to make sure that the child gets back and forth from school, and they drive those extra miles. I know of a situation where there's a parent that lives in another county. Those are situations where the child does go to school in one area, but anytime there is a school break or the weekends are designated for that other parent, but they always make great arrangements for if there's a vacation or if there's something going on. I see the parents coming in, traveling for sports. So I've seen lots of situations where the parents, when the shared custody is the core, I've seen so many families do a great job at making that work. Thank you.
Senator Kolb?
Thank you, Mr. Chairman. Good afternoon, Ms. Pavey. How are you? Hope well.
Yes.
Long
Thank you.
drive.
Yes.
I think, what I'm hearing is we're kind of talking by each other. So we're talking about one scenario. Tell me if I'm wrong after I'm done.
Okay.
That, things are working out great because it's joint custody, shared custody, and the parents are getting along, right?
Right.
This bill is not for that. This bill is designed to deal with people where it's not working so well, where the folks aren't getting along, and how can we move shared joint custody as being a high priority for the judges, right? That's what I see we're talking about here. In a world where people are getting along, we don't need a bill like this, okay? They get along, everything works great. I agree with you 100%. I agree with what you're saying, but we're dealing with something where it's not working. And we're trying to figure out just how do we prioritize what we're trying to convey to the judicial system about what is the best outcome for the child in the long run. But there's many, many factors here. So it's not simple, it's not short. And so I think we need to stay on target about, we're trying to talk about what's best for the child in a situation where the parents do not get along and they weaponize the ability to, with the the whole deal.
Yeah.
So I just want to hear your opinion. We're talking about that being the issue, of a confrontational situation, and what do we do on trying to remedy that? So that, and I agree with what you're saying. I'm just saying, I just want to refocus the conversation back to what this bill's trying to accomplish.
Chairman Olson, thank you. Senator Kolb. To me, this bill, when there's a divorce, there's so much else going on. So once they're separated, there's not the cleaning or the separation of duties as husband and wife. The focus goes right onto the children. So all that goes by the wayside. And so the only concern is now is a focus problem of focusing on the kids. And I think that with a shared custody arrangement in the beginning, that's something that they can work through as adults when it's just that situation that they're focusing on. And I hope that they could but they can go back to court if that's a problem down the road where they're still not getting along. But it helps them just focus on shared custody of the child in their best interest and kind of helps them move forward in working together and raising the kids. Thank you.
All right, thank you for your testimony.
Thank you.
Ms. Lance, welcome.
Thank you, Mr. Chairman, members of the committee. My name is Beth Lance. I'm here on behalf of the Wyoming Trial Lawyers Association. Just to inform you, our Trial Lawyers Association has a whole section dedicated to family law practitioners. And so this bill has been presented to that section of our association, and they have weighed in on this bill, and they have weighed in with some concerns. I would say Their concerns would echo the testimony you've heard here today of both Ms. Butler from the court's perspective and from Ms. Fournier from a family law practitioner perspective. And so I don't want to sit here and repeat things you've already heard. But I will tell you, when I looked at this bill and what other states have done, where it's a absolute presumption, where it is a shall be shared custody, I was only able to find 3 other states in this nation that actually do that. They are not surrounding states. It was West Virginia, Kentucky, and Arkansas. And so it's certainly not something that we're seeing, some large numbers of states going towards. What I think we've seen from a national level both and here in the state of Wyoming is we have seen other ways in which states are making shared custody completely on par with any other type of custody. And I think we are seeing it ordered much more often than you would have seen in years past. And so there is an evolution towards it, I think quite appropriately. Our membership certainly appreciates, from a policy perspective, shared custody. And as family law practitioners, we are absolutely every day filing cases where we are requesting that to be what the courts order. And so it is certainly something that we seek in many of our cases, but as you know, not all, right? It's not a one-size-fits-all kind of solution. And I think the concern is, does this bill even appropriately address all of the exceptions that may actually be necessary in order to be sure that we are still considering the best interest of children and just the best interest of families? What fits that family and their dynamic? One thing I would add, we've talked a lot about divorced parents in custody, but I just want to reiterate that this doesn't just apply to divorced parents. We have many parents who have children outside of marriage, and that can cause many more challenges. They maybe never loved each other. They weren't in that type of relationship. And we're talking about those people then navigating parenting and custody. And so it just is very difficult, I think, to assume that there's a one-size-fits-all kind of solution for these children and these families. And I think that's the concern with the bill. I think there's concerns because there are parts of this bill that seem a little contradictory between still upholding the best interests of children, but at the same time making it a requirement for a shared custody arrangement, and then only having very minimal exceptions. Mr. Chairman, you had brought up the idea of on a temporary custody basis. As you know very well, these cases to litigate and come to a final order can often take many months. And so what do courts do in the meantime? Where do children live in that part of the time, in those 6 months before there's a final decision, right? And, often I will say, again, I'm seeing our judges absolutely looking at 50-50, particularly in that pending time period. However, I do have concerns if the courts would feel that that was their only option and that their only exception was if a parent had actually been convicted of some kind of crime. I specifically just finished a case where the father is now in prison for severely sexually abusing their children. And pending that case, his criminal case was also pending. He had not been convicted. He had been charged and he was facing prosecution, but the entire time that that divorce and custody case was open, he had not been found guilty and he had not been sent to prison. And so it would have been absolutely, just no way that's in the best interest of those children to spend any time with that person while that was pending. It would have been incredibly dangerous for them. And so there just is always going to be a fact scenario that you can't maybe even possibly contemplate. I would hope that I wouldn't have to say that that was a fact scenario that's real, right? But unfortunately, these kinds of fact scenarios are real. These things do happen to children within their families. And so those are some of the concerns that our practitioners had, and I would stand for questions.
Ms. Lance, in the rather heinous example that you gave, we wouldn't have to carve out an exception for that because Romanet 5, any judge, even if they were a terrible judge, would be able to find by a preponderance of evidence that it's in the best interest of those children to have nothing to do with that dad. So I don't think, I hesitate to list out the examples because I think that that could be interpreted by a judge as those being the only paths available. I much prefer just having the judge do a best interest analysis.
Mr. Chairman, I appreciate that. And I think one of the concerns is that a safety valve or not? How does this read? How will this actually be interpreted by a judge? And it's unclear with that preponderance, even if it changes to a preponderance, which obviously my members would support. But even if that changed to a preponderance and a best interest analysis, does that analysis then include the 10 factors within this same statute? Does it not? It's not clear. And so I think there's still become concerns with how a judge will interpret this and actually exercise that.
All right, thank you, Ms. Lance.
Thank you.
Any other testimony? I think you're it now. You're the last one. You're bringing us home.
Perfect.
Before we go online.
Perfect. Mr. Chairman, Jeff Doherty, appearing as an individual today. I'm going to be brief in light of the number of people online. I'll try to get out of here in about 2 minutes. But I did want to thank the committee for all the effort and thought that you're putting into this. I did not come into this session with an interest in this topic. I just had happened to visit with the sponsor with regard to another bill and learned about this bill. I really appreciated the discussion that this body had regarding the exceptions and how difficult that is to craft. And I will confess, Mr. Chairman, I am not an expert in this subject matter area. But what I will tell you is that I do work. I've been a football coach. I've been a hunter ed instructor, a 4-H instructor in livestock, rifle, horsemanship. I do a lot of trail life leader. I do a lot of things where I'm education. I do a lot of things where I work with kids. And I will tell you, I was relieved to hear the testimony of the woman from the court system that did give me some peace of mind. But I will tell you that while I don't think any judges, attorneys, guardian ad litems rise in the morning thinking, boy, how can we torture a parent? They just don't. But I will tell you, Mr. Chairman, in my experience in those activities where I'm dealing with young people, I see a lot of kiddos who do not have the benefit of both parents in their lives. And so, unfortunately, as a coach, I get put into that position of where I become, if you will, a surrogate parent. And I'm happy to do that. But my efforts pale by comparison to an actual parent in that. Mr. Chairman, we had a speaker that had appeared a couple of days ago when this was first scheduled, who you'd know, the son of late Senator Christensen, who's presently in the throes of this. And his case, I don't know if he was able to make it back today on your online, but his case is remarkable because it shows that despite how often the systems that we have in place today go well, he can also show you that at times it doesn't go well, that the guardian ad litems don't always do their jobs properly, that judges who have crushing caseloads can't always get into the detail and will rely on an opinion from a guardian ad litem. So, Mr. Chairman, I did appreciate Senator Kolb's comment on perhaps considering a weighting system with regard to the shared parenting or joint custody. Again, I'm not an expert on these terms, senators, but I would encourage you to do something because I think an extra nudge from the legislative branch to the judicial to make sure that this is an important factor, that kiddos have the benefit of both parents in their lives is what I rise for today. So with that, Mr. Chairman, I'm going to conclude my comments.
Any questions, committee? All right, thank you. So we're going to move online. If you're in the online world, we have quite a few people signed up. So here's what I'm going to do. It's already 1:22. we have to be back by 2, and we have to have some time to consider the bill and possibly work the bill. So all of that being said, I'm going to have to restrict the future comments to 2 minutes. I'm going to use our LSO staff to run a timer. So be thinking about how you can be as concise as possible, but do know that once the timer goes off, I'm going to have to cut you off just because we just don't have enough time. So I apologize for that. And we can let anyone in and just go down the list. Mr. Lang, welcome.
Thank you, Chairman Olson, committee. My name is Jonathan Lang. I was there yesterday and now I'm on my way back, and so I'm zooming in. I'm pastor in Evanston and Kemmer, and I speak in support of SF-17 because I believe it's important because of the presumption that it articulates. We all know that divorce is a tragedy. The children of divorce can't do anything about it, and they're deprived of both financial resources and also parent resources. And we know that the legislature is deeply concerned to mitigate the loss of finances. And this bill addresses the legislature to the loss of the parent. It was said rightly earlier that when parties agree on custody arrangements, the agreement is generally honored. And when they disagree, the court needs to step in, and that's a good thing to hear. But I just want to remind this body that what's written in law has a direct effect on the ability of parents to come to those agreements before the court. Government's policies always place a thumb on the scale one way or the other. And as a pastor, people in my experience make agreements that take into account all the customs or all the contours of law and custom and financial factors and everything else. And so this bill helps by changing the law, by replacing the word expedient with the word is. To me, that's the heart of this. It acknowledges in statute that shared parenting is in fact in the best interest of the child. And that clear statement of shared custody then teaches, and it teaches, gives guidance to the judiciary. It teaches and gives guidance to it changes the counsel that the attorney will give to his client. But most of all, it reminds parents that the best interest of the child in shared parenting should be of paramount importance in their decisions. So I'll stop there and stand for questions.
That was nearly perfect on the 2-minute mark. Any questions, committee? Yes, Senator Craigo.
Thank you, Mr. Chairman. Thanks, Mr. Lang, for being with us. Just a quick question, because I'm looking at this bill, and part of my problem with it is I think it puts too many restrictions or too many directions to the court. I actually don't have a problem with the court being told that joint custody is preferred. I think the courts can work around that. Right now, the statute says that nothing is preferred. To be honest, in my opinion and in my experience, the court typically does prefer joint custody. But right now, the statute says they shall not favor or disfavor any form of custody. I think I could live with that if we didn't have all these other instructions, which essentially I agree with some of the earlier testimony makes it almost mandatory. I mean, it's gonna be really hard to do anything but that. Sitting here, if we just at least made it the preference, right? We made it the favored type of custody. Do you think that would be a good step forward?
Mr. Lang.
Yeah, certainly it would be a good step forward. I just realized I'm not being able to be seen. But yeah, it would be a good step forward. I think that part of the problem is all the Romanettes, and I would really trust you to know better how to deal with those, because the exceptions are put there in order to make the custody viable, or make the shared custody a viable option and not have these kind of horrific consequences. But I understand why those Romanettes can be problematic. But like I said, the essence of this law is to teach the parents and to teach the courts and to teach the attorneys that experience teaches the whole human race that two parents are preferable.
All right, thank you, Mr. Lang. Who's up
Thank
next?
you.
Okay, Mr. Christensen?
Hello, can you hear me?
We sure can.
Um, let's see. So Jeff talked a little bit about stuff earlier, and I won't repeat what he said, but he said it correctly. And in my case, let me watch my 2 minutes here. In my case, I had a 3-year-old, and when my ex-wife decided to leave, we had a baby that was 2 months old. And in the 6 months before she left, the 4 months leading up to her departure, my 3-year-old went to work with me every day because I did all the work. I raised her. I taught her everything she needed to know. When she was at home, she got ignored. And my wife waited until the day she decided to leave and file for divorce, and then moved 285 miles away for the sole purpose, in a text that we admitted to the court, of getting full custody so that she could, whatever her purpose is in being able to obtain. She wanted to avoid shared custody. And so what we ended up with, as Jeff said, was a guardian ad litem who wasn't interested in working hard. She wouldn't talk to me. She did all sorts of stuff. She took over a month to give the court a draft order that was based on stuff she had already written up, and we couldn't get her to pick up the phone. I mean, it was horrendous. And we have a judge who's overwhelmed and took the GAL's temporary recommendation without even blinking. And the reason that happened was only because I filed a temporary custody hearing, and that took almost 6 months to get that in front of the court. And in the meantime, I watched my girls not be able to sleep. I watched them be sick all the time. And until my documents were filed, they rarely even left the house because their mother just wasn't used to taking care of them. And she hadn't ever when we were married, but there was nothing I could do about it because as people all over the state will agree, whether it's judges, guardian ad litems, and attorneys who've been practicing for over 30 years in Lander, Laramie, down in Uintah County, up in Jackson, they're like, well, when the kids are young, everybody just believes they ought to go with mom. And as most of the people talking about today will point out, it's a lot easier to talk in generalities and in assumptions than it is to focus on the facts of a specific case. So let me see. How close am I on time?
You're out.
Okay.
Sorry.
So go ahead. So what questions?
Yeah. Do we have any questions for Mr. Christensen? All right, we do appreciate your testimony.
Okay, I'm in favor of this, and if it passed and make it effective immediately, it would be beneficial for me because I'd have a chance to see my kids more. Thank you.
Wonderful. Thank you. Okay, Mr. Countryman.
My name is Vance Countryman. I'm an attorney in Lander, Wyoming. I've practiced law in Wyoming for more than 30 years, and I've handled domestic cases during that entire time. Immediately, I think that if the court, if this committee and the legislature determines that this should be the law of the land, then the court or the committee should not wait until July to make it effective. Can you imagine if you were pending in a divorce proceeding and your divorce was granted mid-May, mid-June? And so those standards that we now know the legislature wants to apply wouldn't apply, and those standards which you have had to deal with will govern, even though in less than 6 months the law would be different. So I would encourage the legislature to amend this provision so that it would become effective as immediate as possible. Next, the provision about 300 miles is not practical and makes no sense. On the one hand, if you put an amount like 300 miles in there, you should also add a provision that makes that applicable for the 6 months prior to the filing or the 60 days prior to the filing, so that everybody understands what things were like before they decided to get a divorce. They shouldn't be able to move to a point just beyond 300 miles to avoid the application of this statute. The other point is, let's assume you have a family that lives in Lander and Riverton. That shared custody is possible, but even under that circumstance, if you have children in one town that are going to school, they're going to travel 50 miles a day. and the family, the parents are going to travel 100 miles a day. If you have a family that's living in Riverton and Casper, it isn't going to be plausible. The 300-mile limit is not an effective approach and simply is dysfunctional. If the if the committee leaves the statute the way that it is, or the filing the way that it is, the only way you could get a shared custody that is nearly 50-50 is if the typical non-custodial parent would get every weekend, all summer, the Christmas holiday, and the spring break. And I base those calculations.
Mr. Countryman,
Yeah,
that's your 2 minutes, sorry.
very good. Thank you.
Appreciate you tuning in and appreciate your testimony. Thank you. Mr. Hale, you're up next. Welcome, Mr. Hale.
Yes, thank you. Thank you, Chairman Olson and the senators. I'm Matt Hale, and I am the vice chair of the National Parents Organization. I'm the person who crafted the first draft of Kentucky's shared parenting law, which has been so heavily discussed. I led the effort for its passage. I also have the wonderful joy of being a shared parent. My children are in their 20s now. I wanted to address a couple of things very quickly. First of all, it was mentioned a brief moment ago that by one of the in-person testifiers that there are 3 states that have a shared parenting presumption. And those states listed were Kentucky, West Virginia, and Arkansas. It's actually 5 states now. Missouri and Florida have also passed shared parenting presumptions. And the state of Arizona has a law which is being interpreted as it's similar. It comes pretty close to a shared parenting presumption. So it took America 242 years for one state to pass a shared parenting presumption, and now we've seen 5 in the last 6 years, and I think we're going to see more this year. Also, I heard something else mentioned that there was an anticipation that there would be an increase in cases in the family courts due to a shared parenting law being passed. Well, Kentucky answered that question. They did an official administrative office of the courts report. And there's 1 year before the temporary law was passed, then when the temporary law was passed, and then the following year, the 3rd year, when the full-blown permanent law was passed. And you see the law rising, you see caseloads rising, and then when the temporary law passed, it drops, and then it drops further for the permanent law. In the National Parents Organization filing from Don Hubin to your committee, you'll also see that there is a discussion about maltreatment of children, where you'll see a federal report that says in the years studied, there was about a 2.5% drop in in Wyoming's cases for maltreatment. In Kentucky's, there was 33%. The law has it pulled tremendously at 6-1 after it passed, and the law proved so popular that the following year the governor proclaimed the day of its signing as Shared Parenting Day. So I'd be glad to take any questions from you.
The timing was perfect. Questions from Mr. Hale? Senator Grego?
Thank you, Mr. Chairman. I don't know if you heard my question earlier about some statistics regarding dispositions by the court and how many of them are 1 parent or 2 parent or, exactly. I was wondering if your organization might be able to help us with some of this as we move forward, because pretty sure that's a question the rest of the body's going to ask.
It's a very important question, and thank you, Senator Grego. Here in Kentucky, we have requested a DS 600, with that information. It has not been approved yet because they view it as having some cost to do that lengthy of a study. However, we do have obviously anecdotal reports. We have reports in the media, and we have experts who have a really interesting perception. People who work in northern Kentucky, which is near Cincinnati. And we have several different lawyers who work there and say it is remarkably easier to get shared parenting in Kentucky versus Ohio. And there's also significantly less conflict. So we don't have the exact statistics that you're asking for, but we have parents that have reported, media that have reported, and attorneys that have reported that shared parenting custody cases have gone up significantly since the law passed.
All right, thank you, Mr. Hill. Oh, we got one more question, Senator Kolb.
Thank you, Mr. Chairman. I assume it's Representative Hill, but the question I have is about the Kentucky law, particularly. What I can read from the Kentucky law, and I have it, and I compare it to this bill, they are not the same. I think the presumption of shared parenting is certainly the intent, but the bills are not the same. And that's kind of what the debate is here, is just the differences between this. I would have loved to have your language. Frankly, I think it's appropriate, but this isn't that bill. So we're trying to work through this bill, and I guess I hear your opinion about, I don't know if you read this bill, but the language within the bill and what your opinion is of it. Thank you.
Mr. Hill.
Yes, and thank you. And Senator, yeah, I'm the vice chair of the National Parents Organization, and I was the Kentucky chairman when the law passed here. You're correct. Wyoming's law varies from Kentucky's in several ways. First of all, it has Kentucky's law has a rebuttable presumption that child's best interest is equal time with both parents, and this is written slightly differently. It does carry the similar spirit, and the National Parents Organization grades every state for shared parenting laws, and unfortunately, Wyoming currently has a D. This law would significantly upgrade that. We haven't graded it in advance, but I anticipate it would be somewhere around a B. It would not reach perhaps a B plus. It would probably not reach the level of an A that Kentucky has, or an A plus, for instance, for West Virginia. But it would definitely be an improvement, and we believe that it would increase the awards for shared parenting in Wyoming.
All right, thank you, Mr. Hill.
Thank you for having me.
You bet. Mr. Murphy? All right, Mr. Murphy, bring us home. Bring us home.
All right, bringing you home, Mr. Chairman. Good afternoon to you and Senator Crago and Senator Kolb. 2 minutes, ready, set, go. I am the opposite of this story of good shared parenting. I'm what's called a parallel parent. And my personal story, to be very brief, was I have a child with a very rare terminal genetic brain disease. And I see him 3 of every 5 weekends. I travel to see him. And I was removed from custody in terms of decision making. So all of his decisions, his medical decisions that are literally life and death decisions, I'm not a part of those. And how this happened can only be a function of how the courts operate and how divorce attorneys operate. And I think the thing that we may be missing here is just what we would think of as incentive models. And the incentive models right now are to drive parents towards litigation. And what this presumption does is it takes that incentive model away and flips it around and gives parents, much like we heard the pastor from Evanston say, it gives parents, attorneys, and the court the clear message that you're going to be a shared parent and you need to get on board with that. Don't try to move away and relocate. Don't start making allegations, but you come into this thing in a status quo. And that is not the case right now. No matter what a divorce attorney says or what people from the court system say, that is not the case, and it is not happening. I've lived this for 4 years. I've seen it from other parents. My story is kind of an exemplar one with a terminally ill child, but it happens a lot. And I've taken this on. This cause is I'm a champion for it. I believe in it personally. I believe in it professionally. And I think this is a good bill. And like Matt said, it'd probably get Wyoming up to a B or a B plus. And I know Senator Kolb has had some questions and wanted to really see I call it the hamburger deluxe from Kentucky. And I sent that to each of you in an email. It could be, if you so want it to be, a substitute bill. It has all of the language. It has all of the factors included in it. And with 2 minutes, there's no way to go through any more than that. But if you have any questions or want to go deeper into it, I'm obviously very available, and really appreciate your consideration and everybody in the room bringing all their opinions and perspectives to this, because it is a dynamic issue, but one certainly that I believe morally, as members of the state and this nation, kids are the fundamental part of our family, and good families build strong nations. So that's what we're really trying to do here. Thank you.
Thank you, Mr. Murphy. And just so you're aware, we do have your, what would be a substitute bill. I don't think we're gonna get into it. I have reservations about having a substitute bill at this point in time, having not been noticed to the public and having the public comment on it. Substitute bill should be a really rare thing in the legislative process, so we do have it. I think some of us would love to have worked that bill, but unfortunately, it's just not the one we have in front of us.
I certainly understand, Mr. Chairman, and if anything, perhaps it could be a good starting point for an interim topic or future discussions, just given the support that I know there is and the good hearts and the good minds involved in this.
Yes, absolutely. Thank you, Mr. Murphy.
Thank you, Mr. Chairman.
All right, that was it, Pierre? Okay, I'm gonna close public comment. Committee, what is your pleasure? You just don't get to make all those amendments that you've been sitting over there crafting.
Correct. If you move the bill, I will.
Senator Kolb?
I'd just like to explain why I have a position not to move the bill.
Okay, let's hear it.
Yeah, thank you, Mr. Chairman. I agree with the premise of this bill. I agree that I believe there's a problem in the courts. I mean, you know, I hear all the great arguments about how the courts do the final calculation and looking at the best interest of the children, but I haven't heard that they, you know, are really striving towards joint custody. And I realize it's a lot more than just that, but I do prefer the language from another state, which I won't mention. I think it, you know, it goes to the facts of, you know, it's a rebuttable presumption of shared custody. I think that's a great way of going about it. There's too many holes in this. As much as I appreciate the good legislator that came up with this and the reasons why, I've gone through some terrible things in my life with divorces and the same things that everyone's talked about. And for those reasons, and I try to divorce myself from my personal reasons, but the facts are 25 years ago, you know, there was people preferred to have a different custody situation. And I will say, typically whoever has the upper hand weaponizes the children against the other parent, which I find atrocious, but that's a reality we deal with when parents can't get along. I think this bill's trying to solve a problem, and it is. However, it's a complex problem that, you know, it might take a few bites of the apple, in my opinion. And I just think there's too much here to make better. I think the premise of the bill is kind of a little off, you know, just on the methodology and how it was trying to solve the problem. And I just can't get to where I need to be to bring this on the floor and be part of the bill in a committee meeting and responsibly give it to my my co-senators on consideration. So that's where I'm coming from with this bill. I appreciate the effort. I appreciate what it's doing. There is a problem. I will say it should be an interim topic, or I think there's a solution to this that's a lot simpler than that we can all talk about, but we're not there yet. We have in front of us what we have. The bill title's got issues which causes other problems within the bill to change it. So that's a long story to say that I love the premise. I think I know it is a problem. This does not solve the problem. I believe it's going to cause more problems that weren't intended by the drafter of the bill, and I appreciate the drafter of the bill bringing this forward. Thank you, Mr. Chairman.
Senator Craigo, did you want to explain?
I'll be quick, Mr. Chairman. So I'm in the same boat as Senator Kolb. I actually don't mind if we at some point want to move down this road and create some sort of preference for joint custody. I just think this bill does more than create a preference. It creates a mandate, and we take all of our discretion away from our judges to make a good decision. And so I truly believe the way it's written, we would just need to eliminate subsection A of the statute, which is the 10 factors that judges currently use to determine what is in the best interest of the children. And so, I haven't looked, I actually didn't look at the email that Mr. Murphy sent us in the quote-unquote substitute bill, but that might be a good place for us to start if we wanted to take the issue up in the interim and take some time to discuss it and get all the stakeholders to talk about it. Thank you, Mr. Chairman.
All right, Senator Colby?
Mr. Chairman, respectfully, could we put this on the list of interim topic considerations currently, sir?
Done and done. I'll be the briefest of all. As the chairman, it would be inappropriate for me to move a bill. So that's just not something that I'm gonna do. And I think both of you articulated perfectly why you feel that you should not move the bill. So Senator Pearson, that's maybe a first for you, but without someone moving, it doesn't require a second in the Senate committee, but it does require a motion. And without a motion, your bill dies here in committee. And with that, we are adjourned.